You have. You did not want to have it either, so. I haven't seen anybody else file into his case, so.
What's on the screen in front of you?
It was black, because I didn't turn it on.
Maybe I can get it to connect then. Nothing like turning it on.
And the phone unit on the floor.
What's not on?
Oh,
What? Well, that's why I can't hear anything. Okay, and they can't hear me. Is what's on the screen? Okay, see if I can get those things connected. So it looks like we got all sorts of people out there, but no audio. Podium won't attach.
Somebody want y'all on to. Somebody get. Go.
Ms. Feely, will you be representing Mr. Everett, number 5, or is that Ms. Wood?
That's Miss Woods.
You got
And
So IT's on its way. You see him like, hurry him in. Okay.
Mr. Everett is housed in Union City.
Yes, I was gonna try to knock out the 2 South Annex ones first. We got Antonio Johnson and Mr. Everett. I just wasn't sure. I had some questions about Mr. Everett. It was yours. I was gonna talk to you about it.
Got it?
I think
That's someone in Foresight. I don't know how that person's connected.
it's it. Both of it, not.
So while we wait for IT tonight, run to Judge and report real fast.
Yeah, what do you have? I mean, we'll just work around yours. You just have the plea and arraignment for Lofton. Is that it? Okay. Just wait. Okay. No deals. Hey, the podium won't connect. It says that it had been kicked out of the session and it won't add it back in. That hasn't happened. Meaning I didn't kick it out. And the prosecution hasn't connected like the last 3 or 4 virtual sessions we've had. But that's the critical one. If you'll get that one going first, you can sort out prosecution later, but we can't, no one can hear us. But the specific error is Ms. Feely, position 14, yours or Ms. Woods? That's what we're doing first. Okay. Is she on the call?
Good afternoon, Judge.
Test 1, 2.
Why did that happen? I'm muted now. Why would that have happened?
Was kicked out, and so when I was trying to back in, I was saying the same.
Yeah,
You said you didn't, but that's.
okay. I never had that happen before.
I plugged it in regular Zoom, so it's not in Zoom rooms right now, but you can still hear and everything.
Okay.
So.
All right, if you can figure out how to get the prosecution one in too, that'd be great. Yeah, but we can get rolling.
And for additional fun, Ms. Wood did try to pipe up when you mentioned her case and we couldn't hear her. So I don't know if that's an issue.
Right, because this was, I don't think we could hear anything. We'll find out in just a minute, but I was now hearing all sorts of stuff. All right, Ms. Wood, can you hear me?
Judge, can you hear me?
Yes, you're kind of quiet, but we can hear you. We are starting out. The sheriff has asked me to start with Mr. Harris. Mr. Harris, can you wave your hand so I know we've got the right place? Ms. Fell, do we know which one? I was told Mr. Harris is dialing in from Forsyth.
Sorry, he's right here in courtroom 3, Judge.
Oh, right there. That's what we need to do first.
Yes, please.
Okay. It's on. Great. Thank you. All right. Who is handling Mr. Harris's case for the state?
Your Honor, are you able to hear me?
I am.
Are we referring to Mr. Robert Harris?
Yes. Position 14.
It'll be me, Your Honor.
Great. All right. Well, I apologize for the delay, everyone. We had technical problems here in court. The machine that allows me to hear you and you to hear me and everything that's going on in the courtroom was not cooperating, but here we are. Do we have Ms. Rivers? Yes, we do. Ms. Rivers, you ready?
Yes, Judge, I'm ready. Good afternoon.
Good afternoon. Thank you for joining us. So this is position 14. It's 22 SC 181553, State versus Robert Harris. Mr. Harris is in courtroom 3 at the county jail. Ms. Wood is representing him for purposes of this probation revocation hearing. That's all we're doing here today. We've got Mr. Peoples for the state. There is a warrant that I signed in July of this year, a probation warrant that alleges that Mr. Harris violated his probation by picking up new charges. Those charges were possession of a firearm by a convicted felon, and that would have been in June of this year. So about a month after he was arrested for that, I signed the warrant. Ms. Tucson, how much time remains on Mr. Harris's probation in his 22 SC case? Ms. Tucson?
Can you hear me okay?
Now I can.
Oh, okay. It was in the. Okay, I thought you could hear me. I'm sorry. For Mr. Harris, he has 5 years, 7 months, and 19 days remaining.
Great. Okay. Ms. Wood, is Mr. Harris admitting to this allegation for purposes of this hearing, or does he want to have an evidentiary hearing on this?
Full disclosure, I have worked with Mr. Harris in the past. When I went to see him on Monday, I found out he was in Forsyth at that time. I have been talking to his pre-indictment attorney about that new case. She's working on some resolution for that, and this is holding him in. So if we could confirm with him right now, if he's good with moving forward with the revocation today, I can handle it.
Okay. Mr. Harris, what is your preference? The charges that are holding you in, I think, are these new charges about you possessing a firearm. That's the basis for the revocation here. Is this something you want to try to resolve today? Is this something you want to have an evidentiary hearing on?
Resolve it today.
Okay. So, Mr. Peoples, what was the state's recommendation?
Your Honor, the state's recommendation would be to revoke 180 days and return to probation.
All right. Ms. Wood, did you have any recommendation?
I'd be asking for revoke 90 days and reinstate, and I would note that he does have a bond on his new case that he'll have to work through in order to get out.
Okay. And the new case, the 23 CP case, we're all talking about the same thing. The basis for this revocation would be these new charges that Mr. Harris still needs to work through. Okay, got it. Ms. Tucson, is Mr. Harris on probation in any other jurisdiction for any other matter?
No, Judge, it looks like the Cobb County case ended last year. So it's just this Fulton County 22 SC case.
Okay. What were the Cobb County charges?
Forgery, theft by taking.
Okay, but that's all
And then
closed.
and then there was a first offender in 2017 in Fulton County.
Okay. Mr. Harris, anything you want to add besides what I've heard from your lawyer and the prosecutor?
Sir.
Okay. Well, Mr. Harris, I do find that you violated the conditions of your probation by getting arrested on this firearms offense. It sounds like you've got a lawyer for that, and that lawyer will be helping you move that case forward. I am going to revoke your probation for you having been arrested with a gun while you were on probation. I'm going to revoke it for 120 days. You will get credit for the time you've been in. By my count, you are well into the 70s, if not beyond that. When you are released, you will continue to be on probation. The address on your warrant had you at an apartment on Cedar Run in Sandy Springs. Is that still a good address for you? Who lives there?
I do with my mom.
Okay, so that's a place you can go back to?
Yes, sir.
Okay, all right. Mr. Peoples, anything else on behalf of the state?
Nothing further, Your Honor.
Ms. Wood?
Thank you.
All right. That's it, Mr. Harris. So why are you in Forsyth? That's just where they're housing you right now?
Yes, sir. Yes,
Okay.
sir.
All right. Thank you.
All right. Have a good day.
You too. Ms. Farrell, I'm happy to take folks in whatever order you need. I was told that we should do Mr. Harris first, so we did. Should I just go through the calendar otherwise, or is there an order that would help you? All right, well, if I don't hear anything, then I'm going to do it this way. Let's figure out.
Judge, is it possible to do Alpharetta next?
Sorry, say that again.
Is it possible to do Alpharetta next?
We'll do it after I just called up booth 1, so we're going to do that one first, and then I'll do Alpharetta. Okay?
Yeah.
All right. So, sir, in 3 South booth 1, you are?
Keep Lofton.
All right. Well, I picked that. I actually can't do your case right now because the prosecutor's stuck in another courtroom. I just didn't know. Don't leave. Once the prosecutor comes back, we're going to take care of your case, and we'll pivot to Alpharetta right now. Okay?
Yes, sir. Thank you.
All right. So let's do Alpharetta. And that is Camis. All right, position 10. Ms. Feely, would that be yours because it was Mr. Franklin's?
It would, and I have not been able to go out to Alpharetta to speak with him yet, but, and I see that he does have an open case with Judge Adams as well. I think it's.
Right, let me get the warrant up. The warrant I have doesn't refer to the new charges. It's all technical violations. Do you want to go forward with that? Do you need to speak with Mr.? How do you pronounce your last name, sir?
C-A-M-E-S-E.
Camis?
Yes.
All right. So tell me, oops, we can take Ms. Wood off here. Tell me how you want to manage this, Ms. Feely.
So I only see the warrants with the technical violations as well. So if that's all, we can handle that today.
Is your microphone on? Can you bring it toward, it is on, if you'll bring it towards you so Mr. Camis can hear you. Okay. Well, let's get started. This is position 10. It's indictment 11 SC 103815, State versus Shelby Camis. Mr. Camis is appearing from the Alpharetta jail, represented by Ms. Feely. Mr. Peoples, are you handling this one?
Yes, Your Honor.
Great. Ms. Tucson, how much time remains on this probation?
Seven years and 3 months.
Thank you. That's a long probation sentence. Mr. Camis, you've been in jail, according to info I have, for almost 2/3 of a year. That's not just on this probation warrant, is it?
No, sir. I caught a new charge and I bonded out and I've been on probation hold for about 3 months.
Okay, so meaning you posted bond in your new case, which is a burglary, which is with Judge Adams, but you couldn't get out even though you posted bond because of this warrant.
Yes.
Got it. Okay. All right. Well, the allegation in your warrant is that you had been staying, this goes way back to 2020. You were staying at the Baptist Rescue Mission and the probation folks went there to see you. You had left and you were a little behind on restitution. I'm more concerned about you being hard to find than paying restitution, but that's the basic allegation. Mr. Camis, I know you haven't had a chance to speak much with Ms. Feely, the public defender who's helping you with this case. And if you want to have us reschedule this so you can do that, I certainly want to give you that opportunity. But I'll tell you, in the grand scheme of things, your violation is fairly minor. This violation, there may be another one coming down the tracks because you caught new charges, but we're not working with that today. We're simply working with the fact that in end of 2020, probation couldn't find you anymore. And then I signed a warrant in early 2021. This is an old warrant that caught up with you when you caught these new charges. Are you comfortable working these out today?
Your Honor, my attorney, Mrs. Megan Harrison, she's secured housing for me at Making a Way transitional housing in Atlanta. So I was just hoping that you could just give me time served, and I've also had a chance to get back into drug court because that was the source of my problem, was an addiction. I stayed clean several years, almost a decade. I just caught these new charges recently. My housing has been secured. I've had a home and for the last 8 years. I don't know why probation was I had a permanent address for over 8 years.
Okay. Well, I'm going to take all that as you telling me you do want to work things out today. I got one question for you, and then I'm going to hear from Ms. Feely a little bit, and then I'll hear from the prosecutor.
Did you say you've been accepted back into drug court, or you're hoping to get into drug court?
No, they came and they said I accepted it, but because I had not been indicted yet, the ADA refused to accept me going to drug court because I had not been indicted yet. That was the pre-indictment phase.
Okay, so maybe your case, when you get out from this, your case in Judge Adams, which has been indicted, could be referred to drug court. She's not a big drug court referrer, unfortunately, but maybe your lawyer could be extra persuasive and get you that help. Drug court is a great opportunity if it's the right fit. Ms. Feely, what do you want to add about Mr. Camis? I'm interested in hearing about this housing situation because I am inclined to give him time served. He's been in for a long time, but I'd love to modify his probation to include the condition that he reside at whatever this program is.
Yes, Your Honor. So Mr. Camis actually successfully completed drug court in, I believe, 2013. He graduated. Unfortunately, he did exceptionally well after that until he went through a divorce and some other issues and relapsed. But it is our request that Your Honor revoke him into drug court as make it a condition of probation. So in the hopes that Judge Adams would be persuaded by that as well.
Okay. But what about the housing? I didn't quite hear you nodded your head when he was saying it. Are you familiar with, I just want to say the right words in the revocation order.
Understood. And I may have to get those right words from Ms. Harrison, who I have spoken with, but not on that specific point.
Okay. Mr. Camis, can you say again where it is you think you'll be able to live when you get out?
Say that again, sir?
Yeah, can you say again where it is that you think you will be able to live when you get out?
On the day that I get out, I will go back to it's a transitional housing program called Making a Way. My mom has been in contact with them, and they're waiting for me upon my release. So the day that I get out, that's the first place that I'll be going.
If you are living at Making a Way, would you still be able to do drug court, or is Making a Way a residential program and they would not let you leave to go to drug court?
That's where I stayed the first time I successfully completed drug court. That was the housing program that I was in the first time I completed drug court.
Okay. All right. Mr. Peoples, what would you like to add about this situation?
Not much, Your Honor. The state would actually ask to revoke for time served. I think he's been in about 232 days, so the state would ask for 232 days and return to supervision and any additions that the court may deem necessary.
Okay. Mr. Camis, in light of these technical violations, so again, I'm not revoking you because of these new charges. That may happen some other time, although it will come back to me and I wouldn't double revoke you. But the only thing in front of me right now is the fact that you allegedly weren't staying where you said you were going to be staying. And so in probation's eyes, you've kind of gone AWOL. I'm going to revoke 180 days. So that's 6 months. But you'll get credit for time you've already served, which is more than 6 months. I am adding 2 conditions of probation. One is that you reside in Making a Way transitional housing for the first 3 months after you're released. So you can stay longer than that, but I want you to stay there initially so you can get back on your feet and so probation can find you. And then number 2, I'm going to require that you apply for admission as a person on probation to drug court. I can't order drug court to accept you. That's not my authority, but I certainly can require that you, through Ms. Harris, that's your lawyer in Judge Adams's courtroom, apply for accountability court, drug court. And if they admit you, then that will be a condition of your probation. So the requirement is that you apply. And if you're admitted, it's that you complete Fulton County Drug Court. Does that make sense?
Yes, sir.
Okay. Mr. Peoples, anything else in Mr. Camis's case?
Nothing further, Your Honor.
Ms. Feely?
No, Your Honor.
Ms. Tucson, do you need to add anything or give Mr. Camis any reporting instructions?
Well, from what I see here on file, well, the address, you won't be living at the address that is listed, correct? You're going to the transitional housing?
It depends where that is. Where is making away?
The address that I'm going to is 377 Westchester Boulevard, Northwest, Atlanta, Georgia, 30314. That's an apartment complex, transitional housing known as Making Away. I've been there for several years. I graduated from drug court. I stayed there for 3 years or while I was in drug court.
Okay, I got everything but the street name. I got 377.
377 Westchester. It's one word, Westchester. Westchester Boulevard.
Do you know their phone number?
The area code 404-377 8105. And if that's not it, I'm sure you can find it online.
Okay, yes, I'll look it up. And then are you allowed to leave to report, or will you have to call your probation officer?
Am I allowed to do what?
To report to probation, or do you have to stay there full time?
Oh no, it's I can come and go. Curfew is at 11 p.m., but I can come and go to recovery meetings or go to work if I wanted to.
And probation?
And probation, yes.
Okay, so when you are released from custody, just make sure you do report then here to you know where probation is at 276 Memorial?
Right across from ACDC?
Yes, yes. So just make sure you do report to probation within 72 hours, okay, of release.
Do I have someone specifically to report to, or just
There'll be an officer on duty, but you are assigned to Officer Bell, Bell.
Okay, thank you.
Okay, thank you.
Good luck, Mr. Camis. You sound pretty squared away with this. I hope it works out.
Yes, sir. Thank you, sir. I've had a lot of time to think about it.
All right. Well, good. Good luck.
All right.
Thank you.
Val, do you have a Cobb County? Okay, got it. We're going to do Mr. Green next. That's position 9. Ms. Feely, is that you? Ms. Wood, neither.
I thought that Mr. Melnick had filed into this case.
Let's look. He's supposed to be here today. That's pretty. Mr. Green, can you hear me? You can just wave your hand. I can't. You're muted right now. I'll unmute you in a minute. Have you hired Mr. Melnick to represent you? Yes? Okay. We are reaching out to him to make sure he joins the call, okay? Let me unmute you. It'll just be better if we can talk. Let me find you on here. Cobb Booths, you are booth 1. Let's see if this works. Let's try that. Mr. Green, can you hear me?
Yes.
And I can hear you. Fantastic. So Mr. Melnick represents you now?
Yes, he been representing me the whole time. I spoke to him earlier. He should be down there.
Okay, and I bet he is. He is a popular guy, and my staff is reaching out to him. So I don't know if he's going to walk in this courtroom or if he's going to dial into Zoom, but we will certainly deal with your matter. I called you up because, meaning I activated your screen because the sheriff's folks were trying to take care of Cobb next, but we can't talk about your case until we get Mr. Melnick here. I think he's got your new charges as well. So we're figuring out where he is, and I'll unmute you again once we get Mr. Melnick, okay?
Okay, thank you.
Thank you. Ms. Feely, do you have position 4? Do you have any of the cases on here? Why don't you tell me the one case you had?
I have Mr. Johnson, number 4. He also is in Union City.
Okay, I've been asked to do him next. I don't know. I don't have booth control over Union City. So if we could, let's see, where's that? I don't have any Union City on here.
South Annex, maybe.
It should be up on the Norman Gibson, Judge.
Okay, I do have a Norman Gibson. There it is. Let's add spotlight. All right. Are you Mr. Johnson or are you Mr. Everett? Okay, we got to unmute Norman Gibson. I don't have the magical authority to do that. Is there anyone there, Mr. Johnson or Mr. Everett, you can call? Yeah, we need to unmute.
Yes.
Great.
I'm Mr.
Thank you.
Johnson.
All right. Are you Mr. Johnson or Mr. Everett?
Mr. Johnson.
Hey, Mr. Johnson, I'm Judge McBurney. We've got your lawyer, Ms. Feely. You can see her on the screen there. And we've got the prosecutor, Mr. Peoples. Your case is on for plea and arraignment. So you were recently indicted for armed robbery and home invasion. Ms. Feely, is Mr. Johnson waiving arraignment or does he want to be formally arraigned?
Yes, Your Honor, we waive arraignment and I did file the appropriate paperwork.
Okay, so Mr. Johnson, Ms. Feely on your behalf has filed a document that says you're pleading not guilty at this time, which means now Mr. Peoples is going to need to give to Ms. Feely all the discovery in your case. So police reports, if there's body cam footage, whatever there is that the state has that they think proves your case, Mr. Peoples will hand that over to Ms. Feely. She's going to get together with you so you can see it and read it and understand it as well. And then I will see you next, probably in person, not virtually like this, because either your lawyer has filed some motions that we need to hear, like a motion to suppress, something like that, or a bond motion, or you and your lawyer have figured out a way to work the case out. And then I'll bring you back here to make sure we do that. But I'm going to enter in a scheduling order that makes sure these things happen, that doesn't drag out. There'll be a deadline for discovery, a deadline for motions, and then ultimately a deadline, if you're going to work it out, to come in here and do that. Otherwise, we'll get you a trial date. Does that work for you?
Yes, sir.
Any questions about anything I said?
Your Honor, do I still have my same bond that had got granted to me last month?
That shouldn't change, but let me look up your case and see what's in there. Hold on 1 second. So yes, you've got a bond that Judge, it's coming up here. Judge Drake set a bond because you were in jail for more than 90 days without indictment. You got a bond that adds up to some big number, $145,000. So that's still out there. If that's something you can post, you're good to go. Now, you and Ms. Feely may talk about wanting to argue for a bond reduction, and that might be another reason that I'll bring you over here and we'll talk about that, okay?
Okay, Your Honor.
All right, Ms. Feely, anything else on behalf of Mr. Johnson?
No, Your Honor.
Mr. Peoples?
No, Your Honor, that's all from the state.
All right, thank you, Mr. Johnson. You're free to go.
Yes, sir. Thank you.
I don't know if Mr. Everett is there at the South Annex. There he is. Hey, are you Mr. Everett?
Yes, sir.
So I'm curious. This is one of my first sessions with the new South Annex. You have a blue outfit on. The other guy had a red outfit on. What's the significance?
Oh, I don't know. It's not a difference. You say it's not a different colors, man. It's just different colors.
Okay. I wasn't sure if blue, like you're on team blue, so you eat lunch at 1. He's team red. He eats lunch at noon. Just different color. All right. Ms. Wood, are you representing Mr. Everett?
Yes, Judge, he'll be mine.
All right. Let me get you on the screen. All right. This is position 5. We're doing the arraignment for Mr. Everett. Mr. Everett, Ms. Wood, who you can see on the screen, is representing you on your indicted case. You've got a couple unindicted cases as well. Ms. Wood, is Mr. Everett waiving arraignment?
Yes, Judge, and I'll file all the paperwork today.
Okay. So Mr. Everett, Ms. Wood's going to file something, and if you were nearby, you heard me say this to Mr. Johnson, same situation. That's your plea of not guilty. That will trigger a requirement that, Mr. Peoples, is this your case or someone else's?
Your Honor, it wouldn't be my case, but it would be Attorney Precious Marsh, but I'll be handling today.
Got it. So a prosecutor, Mr. Everett, will be getting discovery to your lawyer, Ms. Wood. She'll then get with you. You guys will look over that discovery. If it's video, you'll watch it. If it's papers, you can read it. She'll read it to you, whatever you need. And then Ms. Wood's going to decide after talking with you about whether she should file any motions. I will see you next either to hear those motions or to talk about whether you've negotiated something to work out this case. It may be that Ms. Wood wants to talk to you about negotiating and resolving all 3, because as I mentioned, you've got 2 other charges that are out there. And for any of that stuff, we'll probably bring you over here rather than have you just show up on a screen. Do you have any questions about any of the things I just described?
No, sir.
Okay. Ms. Wood, anything else on behalf of Mr. Everett?
No, Your Honor, thank you.
All right, Mr. Peoples, on behalf of the state?
No, Your Honor, thank you.
All right, Mr. Everett, you're free to go. All right, maybe you'll get a red jumpsuit tomorrow. All right, that should be it for South Annex. Thank you, Norman Gibson.
Yes, Your Honor.
All right, bye.
All right.
Okay, Ms. Farrell, are we good then, just sort of going through the calendar, or is there an order you want to do things at Rice Street? All right, I'm going to do this. Good afternoon. Who is in 3 North, booth 1?
That's number 6, Mr. Newcomb.
Are you Mr. Newcomb? I'll take that as a yes. Okay. Is that your case, Ms. Feely?
It is, Your Honor, and there really isn't much of an update. He still is not competent to stand trial. And I need to, now that Ms. Patterson has transitioned out, I need to loop back in my new social worker, Ms. Ross, but that's with
Okay. Is that Raven Ross? Is that the same person? Okay. I met her on a screen for a drug court. So you'll work with her. Mr. Newcomb is someone for whom you've entered a request that we take some next steps, or where are we in that process?
The process started actually pre-indictment.
Okay.
So he's, I think, still.
That's happened. Is he in the restoration pod?
My understanding.
Got it. Okay. Mr. Newcomb, do you have any questions?
Yes, sir. I got here on June 1st, 2022, and this is my first time seeing a judge. And I've been on the law library, and it says I don't have no yellow Daterlin packets apparently, and something about the 4-4 Team Lou loss law says it's past timeout in Sager sessions to put me in front of a judge that I'm wrongfully convicted in better turn. They brought me to the courthouse downtown. I got here on 6/1/2022. My first appearance was supposed to be on 3/3/2023. And when they brought me downtown to court, I sat in a holding cell and they never called my name. The judge never seen me. I was told that they don't have no verdicts on me, no motion of discovery, or no Daterlin charcoal fight graphites, whatever that is. Then they brought me back to that same courthouse on 4/25/2023, and the judge never called my name. The attorney never talked to me. Then I was told my court date would be on 6/7/2023, a year after I got to jail, and still ain't seen a judge. And 6/7/2023 came, and they never called me out to go to court or nothing. I ain't been arraigned. I'm not mentally incompetent. I have a PhD through Law Webster, through Downtown HPHQ APD, through Squadron Sidron, if you know what that is. And now they're saying, I got this paper right here in my hand. If you could see it from you, saying today's my court date, but I don't have no, they don't have no motion of discovery packet on me. It's past time. It's past time for me to be able to receive one or sign for one. It says on the Benedict and Pisa law laws on the Cobra kiosk on the law library. And it also says that the courts have a 3-strike session that they're out. Failure to put me in front of the judge on 3/3/2023 would be the first strike. Then failure to put me in front of the judge again on 4/25/2023 would be the second strike, and then on 6/7/2023 would be the 3-strike questions. You're out on Insigniasirem, you're out with U.S. law covenancy and Cyrus-Orin outs, if you're familiar with that. I worked for APD. I was an informant for APD for like almost 5-6 years. They call me Lieutenant Alderson with APD, HPHQ. That's my nickname with APD.
Okay, hold on 1 second.
I want to plea out. I don't, it's just theft by receiving stolen property and a drug-related object. I've been in jail over a year now, and I ain't seen a judge. I ain't been offered a plea bargain. I ain't been in front of a judge live and in person. And it says insane and trauma video courts is illegal too on the Cobra kiosk.
All right, my turn. I listened to you. Now it's my turn.
Yes, sir.
So I appreciate you sharing all that. And I understand why you're frustrated, because it's been a long time. I'm looking at where your charges are, and it shouldn't have been this long. Your case, because the charges are not very complicated, was for many months in what's known as our non-complex division. It sounds like you got brought over for court a few times, but didn't get to see a judge. It got transferred to me when some doctors had an opportunity to talk to you and reach conclusions that they reached. And that made your case no longer simple and non-complex. It's now a little more complicated. So that got transferred to me.
Complications.
Well, we got to make sure that you're getting the care that you need to get. And that's what we're working on. Whether you appear on the screen or whether you come over here is more random. Some days, because transportation is limited for the sheriff, I have court virtually. So you'll see you're one of many people who is appearing on a screen. So it has nothing to do with you. It has to do with, I only get to bring inmates over to court certain days each week, but I need to do business every day. So today happens to be one of these, we call it a Zoom day. But next time I see you, it may be in person and we'll have you brought over.
Is there any way I could just plea out today or anything?
So here, two things, two more things I want to add. And I'll answer your question. That's the second thing I'm going to say.
Sure.
The first thing I want to share with you is, I don't know where you read it, but there's no 3 strikes for a court. There's 3 strikes for a baseball player, and in California, there's 3 strikes for a criminal defendant. But there's no such thing in Georgia about 3 strikes and the court or the judge or the case is out. That's number 1. Number 2, it may well be that you can resolve your case. Ms. Feely should talk to you about that. I know she will come see you soon. She should talk with the prosecutor, but based on how long you've been in jail, my hope is that a thoughtful prosecutor would be in a position to say, we could work this out. But Ms. Feely, hold on, Ms. Feely, you've been there more than a year. You've been there about 440 days. That's a long time for the charges that you're facing.
I don't want to die in this jail.
You're not going to die in this jail.
I feel like been 15 people to die up on this floor.
But that's not going to be you.
Yes, sir.
So Ms. Feely will talk with you some. She needs to be comfortable that if we took a plea, if you came in here to take a plea, that you understood everything and weren't talking too much about a PhD with APD and that kind of stuff. So that's what's going to happen next is I'm going to look through your file. We're going to figure out the right way forward. And I am making sure you get put on another calendar soon. And I'll ask that it be one where you get brought over here so you get to see a judge face to face and not on a screen. Okay.
I also don't have no yellow. They also don't have no proper verdicts. The redheaded lady, that's Lucy Kyles Woods, she told me when I went to the courthouse that the judge didn't have my name on docket. They don't have no verdicts on me or motion transcripts or any Daterlin packet scripts. And it says lack of data on I asked the guards here, and the guard says lack of Daterlin packets means wrongful conviction and better turn. And that I might be wrongfully conviction and better turn through ludus laws. I've been asking the guards here for paperwork and on the law library, and they say they don't have my last yellow certificate was 3.5 years ago, and it was for criminal trespass. This jail says they don't have no graphites, whatever graphites are, or motion or verdicts on me. And I was also told they only have 72 hours to 2 weeks to give you a motion of discovery packet or verdict.
So Mr. Newcomb, I'm gonna talk a little bit, and then I'm gonna let you leave the booth. You don't need to stay stuck in there much longer. There's no yellow packet. There's not a 72-hour rule. You are certainly, let me finish. You are certainly entitled to your discovery. And if Ms. Feely, who's newer to your case, you had a different lawyer when your case was in a different courtroom, she can certainly get you that discovery so that you've got that information. It's out there. No one's hiding it. We'll make sure it gets to you. But my promise to you is that I will see you on one of our next available calendars so we could talk a little bit more about this, okay?
And when will that would be?
Well, I got to check my schedule, and I need to talk a little bit with Ms. Feely about what her next steps are for you, and then we'll get you back here, okay? Mm-hmm. All right. Thank you for your time.
Sir, I'm done.
Yep. We should, Mr. Peoples, is Ms. Sellers plugged into this case from your office?
I'm going to loop her in, Your Honor. Normally, whenever we have something, defendant who I flag, I normally send her an alert or an email after court. Okay.
Let's make sure it's on her radar. And Ms. Feely, as best you understand, there's been an evaluation. We've got results, and unfortunately, it's not a Georgia regional setting. It's a restoration pause. It's not necessarily, unfortunately, but folks are working on that.
That's my understanding. And I actually did push back a little bit about why on a case like this was route that we went down.
Keep pushing back.
So, because I don't know if the court knows anything about this case, but he rode around in a golf cart. So, but that's actually pretty good for him, how he uses it. So.
Well, talking to Ms. Ross is key, because I think if you can line up a set of resources, then with Ms. Sellers's collaboration, we might be able to come up with some disposition that might not even require a plea.
That's my hope. And I just emailed Ms. Ross to request that she visit him and also start looking for supports on the outside if we can get him released.
Okay. What I'm going to do is set it down for an inquiry calendar 45-ish days out, give or take. It will be in person. I don't want him on the screen again. He'll come over here in person. And we can extend that if Ms. Ross tells you I'm close, but it's not time. I just want to balance I'll chat with him again. That's fine. And that may be a good thing. But I don't want to have too many cycles of that because then he'll say, but why are we doing this again?
Yes, understood.
Okay. So Mr. Peoples, you'll let Ms. Sellers, you'll get this on her radar.
I just sent her an email, Your Honor.
Excellent. Okay. And this is now big time on Ms. Ross's radar.
Yes.
All right. Thank you. Let's go here. Good afternoon. Who's in 4 South Booth 1? You. Yeah. What's your name? Say it one more time.
Holly.
Mr. Holly?
Yes, sir.
Is this another Melnick case?
No, I actually tried to visit him on Monday, and there was something going on that floor, and they weren't allowing visitation at that time. So I actually have not spoken with Mr. Holly, but I think it looked like something we could maybe handle anyway.
All right, let me get you on the screen so he can see you. All right, and Mr. Holly is not Shabazz Morgan. Those are two different, because somehow his CP number showed up underneath both Mr. Morgan and Mr. Holly.
I have met Mr. Morgan and
Two separate people. Okay, so that's just a typo on our calendar. 281272. One. Get his situation here. I can't really put you in a breakout. You think we can go forward?
I actually am in the Zoom too. I would just have to step out.
Go outside. Do you want to talk with Mr. Holly for a minute?
I see that he does have some pending CP numbers, so this may not be one that is as easily work outable. As I
So
thought.
yeah, let me just lay the groundwork. I have the warrant in front of me, and the allegation is that he had a reckless driving, had a gun on him, and that was in May of this year. That's one of the two CP cases, the one ending in 272. He has a more recent one, which is something that happened in the jail. It's ag assault / riot. So one of the CPs is this warrant, and then the other, I think, is just new enough that it hasn't caught up with probation.
So would it be possible for me to step out and speak with him?
Sure. Mr. Holly, I'm going to move you into a breakout room. You're not going to have to go anywhere. You stay right there, but I'm going to move your video and audio feed into a breakout room so that you can speak privately with Ms. Feely, who is on the screen right there where it says defendant. She's the lawyer who is going to help you with your probation revocation. Let me get one last piece of data. Ms. Tucson, how much probation remains on Mr. Holly's case? That was a long time, Mr. Abate.
Sorry, Johnny.
One moment there. I think I put the wrong case number because there were multiple cases that pulled up for him. It looks like this one is the 19 SC Fulton case? Because
That's
there's
what's
a lot.
on my calendar. 167302.
Okay, yes, because there's another one that pulled up that I thought was so this particular one has this one 7302 has 5 years, 11 months, and 22 days.
Okay. All right. So there's a fair amount of time left.
And can I ask one other thing? It might help with whether we can go forward today is if Mr. Peoples has a recommendation if we do go forward.
Just send you a message.
Got it.
Okay. All right. Let's see if we can make this work. So I should send the Lee Feely into the breakout room. All right. Manually. Can I add someone else to that? South Booth. All right, he should be in there, and I think it flips it. I muted him, and so in there he should be unmuted. If he's not, let me know, and I'll figure out a way to unmute him. Okay.
Thank you.
Sure. All right, let's go back to Mr. Lofton, who's been waiting. That's Ms. Wood. It is Ms. Wood. Great. Okay.
Judge McBurney,
Yes, ma'am.
I have been informed that he and his family are gonna hire private counsel. I don't think anyone has entered an appearance.
Okay. Well, let me get him on the screen and you on the screen, and let's talk about it that way. All right, Mr. Lofton, you're back. We've got our prosecutor now in court. In your case, you're charged with murder. And Ms. Wood, who you see on the screen there, is the lawyer that my records say had been appointed to represent you. But Ms. Wood was just saying that maybe you were going to hire someone, or your family or someone was hiring a lawyer for you.
Yes, sir. We was asking, me and my family was asking for a continuation because we feel like in this alleged situation that we needed a private attorney to properly represent me so we can get me back to my family and get this situation dealt with.
Okay. Is there someone in court for Mr. Lofton? Hey, and you are his wife. Okay. Are you Mrs. Lofton? Okay. Do you have an update on getting a lawyer for Mr. Lofton? Who is that going to be? Jerome? Okay. How far along are you in the process of retaining Mr. Jerome?
It's just, I live out of state and I'm supposed to see him like while I'm here.
Okay. So that's all good. I just want to move Mr. Lofton's case out far enough that by the time I see him next, Mr. Jerome is on board, because it really doesn't help anyone to say, hey, it's been 20 days, where's your lawyer? And then you're doing your best to retain him. So if we reset this for 30 days, is that enough time, do you think, to get Mr. Jerome on board, or should we push it? I don't want to push it too much further out, because if in the end it turns out that financially you all can't support a private attorney, the truth of the matter is some of the best criminal defense attorneys in Georgia sitting right at those tables. So Ms. Wood and Ms. Feely, that's all they do for a living. But that's not my call. That's Mr. Lofton's call and your call. And you are 100% entitled to hire anyone you want, but within reason. If you tell me and you haven't, it's going to take 9 months to get this lawyer. We're not going to wait 9 months. We'll start the case and someone could bring Mr. Jerome in 9 months later and we'd see where we are. But it doesn't sound like you need that much time. Okay. So, Mr. Lofton, I don't think you've been able to hear your wife because she's not near a microphone. We don't have one out there in the gallery. But she explained to me that she's been in active discussion with Mr. Jerome, that is a defense attorney here in Georgia, a criminal defense attorney, and that your wife believes that if we reset your hearing that we were going to do today for 30 days, by then Mr. Jerome will be on board and could handle the arraignment and I assume everything else going forward on your behalf. Okay?
Thank you, Your Honor.
You should thank your wife. I'm not paying Mr. Jerome.
Oh, thank you, baby. Yeah, till I said thank you.
Okay, she can hear you, so she heard the thanks.
All right, love you, and Kiana.
All right, that's all you get to say. We'll reset this 30 days. I'm going to make a note that we should be expecting to see Mr. Jerome. Ma'am, if you learn for whatever reason that you can't afford him or you learn something that tells you you don't want to hire him, then please let my staff know because we'll get Mr. Lofton back here in less than 30 days if the decision is, you know what, that wasn't the right choice for us for whatever reason, and we're not going to be able to afford anyone. I don't want to slow things down for Mr. Lofton, but I'll do this one time 30-day. Let's wait and see, and we'll see what happens. Okay. Ms. Wood, do you have anything else?
No, Your Honor, thank you.
All right, Mr. Lofton, any questions about what we've talked about?
No, sir, I was, thank you for hearing it and, thank you my wife too.
Okay, I'll do that. All right, you're free to go. Oh, the guy is muted? Try now, ask her now how it is. What state do you live in? Okay, so Mr. Lofton was living in Birmingham, but then got arrested and I've got down, he's been in for almost a year now. Eesh, okay, all right. Yeah, you may want to Google search Jerome before you put a lot of money there, just so you have full information. Okay, all right.
Thank you.
Sure. Well, Mr. Bate, thanks for coming back.
Thank you, Jeff.
Yeah.
So long.
No, that's all right. I was bugging the joke. Where is this guy? But something about an interpreter, and so.
Shapiro didn't realize you had 3 or 4 cases on your list.
Typical Shapiro move. I took him off mute now. I don't know. I can try sending him back in. I'll try that. Okay. Yes, sir. Thank you. Good afternoon. Who is in 4 North Booth 1?
William Walker.
All right, that's position 13. Ms. Wood, is that yours?
It can be, Judge. I think Miss Feely had seen him, but I'm happy to handle it if he's cool with that.
Well, let me look. Hold on. Ms. Feely's coming back, so we'll just do it that way. 1, was he ever off mute?
It appeared that he was off mute, but I still couldn't hear him, like the
Oh.
icon went away.
Okay, sorry about that. We have Mr. Walker on the screen. Can we pivot to him for a second?
Yes.
Great. Okay, this is position 13. It's 20 SC 175578, William Walker. Ms. Tucson, how much time remains on his probation?
Sorry about that. For Mr. Walker. Let me see.
For every other probation revocation on the calendar, how much time remains? So if you could just have that ready, that would be great.
No problem. For some reason. On 5578, 4 years, 5 months and 12 days.
Are there other cases?
Not for there other cases in Clayton
Got it.
that are expired.
All right. So, Mr. Walker, you are on probation out of Fulton County for a bunch of counts of aggravated assault, a few other charges. I signed a warrant in November of last year that alleges that you committed a new crime, possession of a firearm during commission of a felony, and possession of a firearm by convicted felon out of Gwinnett County in October of last year. That's when you allegedly did those things. I signed the warrant in November, and that has caught up with you. Looks like you've been in jail now for about a month and a half. Ms. Feely, is this something that Mr. Walker is contesting and we should set up an evidentiary hearing, or what is his preference?
He would admit for probation purposes that he was arrested in Gwinnett.
Okay, with a firearm?
Yes.
All right. What is your recommendation?
So we're asking the court to consider the time that he has been inactive as 54 days. So essentially what happened in Gwinnett, he is still out on bond for that case. So he hasn't been adjudicated guilty or anything like that over it. And then he just didn't get in any more trouble after that and just got caught up in a traffic stop. He's 21 years old and he's got a little girl who turns 1 on September 17th, which is next week, who he obviously hasn't seen for the last almost 2 months. Her name is Kaylin, I'm sorry. And he usually gets her every other weekend. So he works at a company called National. He goes from town to town rebuilding like Family Dollars and Walmarts and stuff like that. He is concerned he may have lost that job, but he was gainfully employed when he was arrested on this warrant. So we're asking the court to allow him to hopefully get back on his feet and sentence him to 60 days reduced to time served.
Okay, Mr. Peoples?
Your Honor, the state's recommendation would be revoke 180 days and return to probation. I'm concerned about the firearm.
Sure. This case doesn't look like it was a firearm. I don't know if it's just aggravated assault with a vehicle. It's a bunch of, it's a weird set of charges. I'm gonna take a look at it.
Right. I mean, about the potential of the Gwinnett case, I thought I heard the court say possession of a firearm as a.
Well, you heard correctly, and I share your concern. It was noting that the case for which Mr. Walker is on probation did not also include a gun. And I wasn't disagreeing with you at all.
Oh, understood, Your Honor. It's a vehicle.
Yeah, I'm looking. It's a mess of an indictment, and he did have a gun. It just wasn't the offensive part of the aggravated assault. Let me see what the final disposition was. Okay. All right. Mr. Walker, anything you want to add?
There's one other thing I.
Oh, yes, Ms. Feely.
I forgot to mention that and this is not news to the court by any stretch of the imagination, but Mr. Walker did share with me that the shower is clogged, the water is dirty, there are bugs everywhere. And so he also just the general concerns of if the court decides to make him stay there for longer.
That is not a pleasant place.
Correct.
Got it. Okay. All right, Mr. Walker, you don't have to add anything at all. Your lawyer's done a good job of sharing with me your situation. Is there anything you want to add?
Sir, I'm 21 years of age. I'm very young, and this is my first daughter. So I would like to go home for her first birthday. I promise I won't get in any more trouble. It's not a safe place for me.
Got it. Okay. Ms. Jackson, good afternoon.
Good afternoon, Judge.
We missed you. I think it was yesterday. I had a Ms. Hardy helping out.
Oh, yeah, they had me scheduled in another court yesterday. It was a busy day.
Sounds like it, because Ms. Hardy was having to bounce between Judge Ingram and me, but she did a great job. Can you share with me what criminal history information you have on Mr. Walker?
Okay, he has 8 cycles. The last arrest was November the 7th, 2022. And that was in Marietta, Georgia, for burglary in the 2nd degree and theft by receiving stolen property and theft by taking. There is no disposition for that arrest. He does appear to be on probation in Clayton County for theft by receiving stolen property. That disposition date was January the 17th, 2020, and the term is for 5 years. Nothing in addition, Your Honor.
Thank you. All right, Mr. Walker, you're a young guy to have racked up all that business that's been going on. I hope when you get out, your focus is Kaylin and either getting back to that job you had or a different job. But you've got this thing pending in Gwinnett now. You've got probation out of Clayton and then probation from Fulton County for what was a pretty serious case. You got sentenced to 8 years to serve 1 with a balance on probation. I'm going to revoke 180 days of your probation, reinstate the balance, and hope that if I see you again, it'll be because you have rebuilt some Dollar General I'm going into. I appreciate your time, and we'll see you around.
So what is that? I don't reinstate 180 days. What does that mean?
So you're not done with your probation. So reinstating the balance means that when you're done with your revocation, you'll still be on probation for this case.
So does that mean I return home today?
No, you'll do a little more time and then you'll return home.
Okay.
All right. Good afternoon. Who's in 5 North, booth 1?
Harris Anderson.
That's position 3. Ms. Wood, your case?
Yes, Judge, he's mine. I had actually filed a waiver, but I sent Mr. Peoples an email. We might be able to work this one out today.
Okay, let me get you on the screen for a second. There's Ms. Wood, there's Mr. Anderson. Mr. Peoples, is there something you and Ms. Wood should chat about? We can get Mr. Anderson back in here in a minute.
We did speak briefly. I attempted to reach out to the victim in this case, so unfortunately we can't close it because I wasn't able to reach out to them.
Assuming you're able to connect with the victim in the near future, is this something we could bring Mr. Anderson back for, either in person or on Zoom, to resolve? And whatever Ms. Wood shared with you, if the victim, I don't know, would be confirming it or who knows what, I'm just looking at the charges. But if you hear from the victim something consistent with what you heard from Ms. Wood, you'd be in a position to resolve the case?
Yes, Your Honor.
Okay. What is second-degree carjacking?
No weapon used, Judge.
Okay, got it. Mr. Anderson, so you did file a waiver, Ms. Wood?
I did this morning, Judge.
All right. So, Mr. Anderson, you may have heard me say this to a few other folks. It sounded like your case might have a slightly different ending today than the others, but we'll just hold off on that until the prosecutor can speak with the alleged victim in this case. By waiving arraignment, you're basically entering a plea of not guilty. Ms. Wood will get the discovery in the case and she'll come talk with you about what's in there and figure out a good way to move forward. It sounds like she's already figured out a good way to move forward because she's talked to you. We need to see what the state does with that. Monet Lewis, I guess, is the person that the state's going to try to talk to in connection with the information that Ms. Wood shared. And I'll see you next, either because there's some motion that needs to be argued or because the state reached Ms. Lewis and we figured out a way to work your case out. Do you have any questions about any of that, Mr. Anderson?
No, Your Honor.
Okay. Well, Ms. Wood is going to continue to work hard on your case like she has so far. If it's something that can be a plea, then I'll just get you on the very next available calendar. It could be in person, could be virtual. My guess is you'd prefer whatever is quickest. Is that correct?
Yes, Your Honor. I've been in here for almost a year now, and I'm just ready to handle this case for me and the victim.
Amen. I see the numbers on here. You've been in there for a long time, finally indicted, and it sounds like Ms. Wood is in a good position to help you work it out. So, Mr. Peoples, my request is that you let Ms. Nelson know as soon as you're able to figure out what's happening from the state side. And that may not be that it's going to work out, but we'll get Mr. Anderson back here if it is something that can work out. Okay?
Understood, Your Honor. And if it's something, if the court knows, do you think we'd have any time or space next week if I can reach out to her?
We do, yes. Next week would work.
Okay.
All right. Thank you. All right, Mr. Anderson, you can go. Thank you.
Thank you, Your Honor.
Good afternoon. Who is in 2 North, booth 1?
Kevin Fitch.
Position 1. All right. Hey, Mr. Fitch. Who is handling this for Mr. Fitch?
He's mine, Judge, and I have a new offer. If I can have a breakout session, this might resolve today.
Okay. Mr. Fitch, I'm gonna do my best to get you, I can get you in the breakout room. Where I've been having trouble is making it so that Ms. Wood can hear you. You'll be able to hear her, and she's gonna share information with you. You guys may need to develop a thumbs up, thumbs down, however that's gonna work. But I'm gonna move the 2 of you into a breakout room so she can share with you what the state's recommending, and maybe you can work your case out. It's a older indictment. It's even older arrest. I'm not quite sure. I guess you missed court at some point and that warrant caught up with you. But I'm gonna let you all talk about it and we'll figure it out. Okay.
Okay.
All right. Fingers crossed about this breakout room.
Thank you, Judge.
Sure. All right, they are in. Mr. Melnick is here. Hey, Mr. Melnick.
Good afternoon, Your Honor.
And you have
Mr. Green, Ronquell Green?
Okay, is he the gentleman who is in Cobb?
Yes.
There he is. Let me get him back on. All right, Mr. Green, can you hear us?
Yes.
Okay, you should be able to see on your screen Mr. Melnick, who is joining us. I think he's in Gwinnett County, one of his many counties he has to go to. He is here, and let me pull up. I don't know if it's already open. Yes, Green. All right, so this is position 9. It's indictment 10 SC 92040, State versus Ronquell Green. Mr. Melnick is here on Mr. Green's behalf. Mr. Green is appearing virtually. Got Mr. Peoples for the state. Ms. Tucson, how much time remains on Mr. Green's case?
6 years, 11 months, and 25 days.
Thank you. Mr. Green, in March of this year, signed a probation warrant that alleges that in February of this year, you were arrested by the Atlanta Police Department for possession of cocaine and having a firearm in connection with that cocaine. I think that's your pending case as well. You have an unindicted case that Mr. Melnick represents you on, and that is the same situation. Mr. Melnick, is Mr. Green interested in resolving this today by stipulating to the allegations, or does he want an evidentiary hearing?
Judge, we will stipulate for purposes of this hearing.
All right. What do you want to tell me about Mr. Green and your recommendation?
Excuse me, Judge. Mr. Peoples and I have discussed this case. Mr. Green has been in continuous custody since February the 14th of this year. Judge, I'm not going to get too much into logistics here because I think we have a joint agreement or a joint resolution. But on this particular indictment, Mr. Green was charged only with simple possession of ecstasy. And he entered that plea on November the 29th of 2010. Quite honestly, I don't know how that offense would carry this number of years of probation with it. But like I say, I'm not going to get into the semantics of it right now because I have not had a thorough opportunity to research that issue. At that time, I mean, and I understand why the probation office is making that representation. He entered pleas on other charges that had much more serious consequences than this particular one that is in your division. So Mr. Peoples had proposed that we revoke 200 days with credit for time served back to February 14th of this year. And I believe you were going to continue him on probation, if I remember correctly, although for that purpose, I will check into it to see whether this should still be an active probation based on the charges that he entered a plea to.
That would be the state's recommendation, Your Honor.
All right. Thank you for sharing that. I'm just looking in the docket. I can't, because the case is so old, the only item I can open up is the petition to revoke, which would be 13 years after a plea to a charge that, to Mr. Melnick's point, I don't understand could carry that much probation, but okay. So revoke 200 days, credit for time served, and then state's position is reinstate on probation. Ms. Tucson, is Mr. Green on probation on any other cases?
Well, this case is, I guess it's, I don't want to say altogether, but there are 4 active warrants, so all those will be included. I guess just this one was on the on the calendar, but it is the 4 cases he has. 08 SC 71171, and then 09 SC 80799, and then the 10 SC 92040, which is the one on the calendar, and then 10 SC 94905. They are all active warrant status.
Oh, okay. So Mr. Melnick, that complicates things a little bit because I guess to your point, those belong to other judges. So we are oh yeah, they are more serious. Here's what I'm going to do. I don't want to make things more complicated than they need to be for Mr. Green or his lawyer, Mr. Melnick, because it sounds like he's got a complicated situation. In the case of 10 SC 92040, and in that case only, I'm going to revoke 210 days, 210. Mr. Green will get credit for the time that he served. And in the case of 10 SC 92040, and that case only, I'm going to suspend the balance of probation. Can I do that, Ms. Tucson?
Did I mute? No, I didn't mute. Well, it looks like from what I'm looking at in portal, I believe you did sign these warrants. For him.
For cases, Ms. Tucson? I'm sorry. Because honestly, Judge, we've had a hard time getting through some of these cases.
When you say getting through, I don't know what you mean.
I didn't state that very well, so I understand why you don't understand what I mean. We've had a hard time getting these cases calendared.
Okay, so
I guess what I'm saying is the warrants that I have uploaded here on these cases, Judge, you did sign all 4 of them.
okay, well, that's probably because you sent me all 4.
Yes.
I don't typically look at the case in Odyssey to make sure it's mine. I rely on probation to send me, DCS to send me warrants for my cases and not someone else's. I just happened to look up one of the other 3 cases, the one ending in 799, and that's now a Judge Schwall case. It was a Judge Ellerby case, which means it's Judge Schwall. And I am okay with handling the probation in those other cases, but those other judges would need to say no problem. So that may be the most effective way of doing it. We have a couple options. I see three. One, all we do today is deal with the case ending in 040, the possession of ecstasy that probably shouldn't be on probation right now. But we can come back and deal with the other three when either Mr. Melnick or Ms. Nelson has been successful in reaching out to the other judges or litigation managers, getting the green light for me to handle those revocations.
Judge, I'd like to do that if that's okay.
Okay.
Available. I am supposed to try a case next week, but either myself or I can find somebody to be available just to handle that, to handle those cases next week.
What you had worked out with Mr. Peoples was a disposition of all four, even though some of them weren't in the division where Mr. Peoples works?
I'll have to leave that up to Mr. Peoples. Are you okay with that?
Your Honor, I'll have to take a look at the others that aren't before the court.
Okay.
But it was for this one specifically.
Well, why don't we at least take care of this one, and I remain open to moving the others along as well. Mr. Melnick, are the other three all in the same place, or are they scattered across judges?
Unfortunately, they're scattered, Judge.
Okay. You've got your work cut out for you, and you're going to be in trial. But for looks like there are two different judges for those three cases. For this case, the one over which I have clear jurisdiction, I'm doing what I said, which is revoking 210 days, 210, and giving Mr. Green credit for the time that he served and closing this one out. That does not affect the other three, but I'm happy to consider the other three if people can get that teed up. Mr. Green, do you follow all the stuff we've been talking about?
Yes.
I didn't realize you were such a busy guy and had these other cases.
It was my young years.
Definitely. What I will note from the one case that was assigned to me, I mean, it was assigned to someone else way back when, is that you took your plea in 2010 or whenever you did, and there's been no entries in that case. So seems like you've been doing okay until whatever just happened. That we'll work through that with the other cases. Mr. Malik, did you have anything else?
No, Judge. I did have those consent bond orders that we had presented to you earlier today. I don't know if Ms. Nelson had indicated that you might have some questions for me about them. I don't want to take up everybody's time on that, but I just wanted to bring it up for now.
This is involving the guy whose name starts with Z?
Yes.
Yeah, I maybe didn't send it. I thought I had sent out one last email. Maybe I didn't finish it before I had to go off and do something else. A little more information I needed from you or Ms. Willingham before I signed off on those. So you'll get an email from me.
Okay, thank you, Judge.
All right. Mr. Green, any other questions?
Yeah, so I'll be coming back next week if everything work out with
Yes, if Mr. Melnick is able to get in touch with the two other judges, Schwal and Barwick, they're the judges who have inherited your three other old cases. And those judges say, that's fine, McBurney can handle it. And most judges say that, then we can reconnect and see what we're going to do. Okay.
I'll let you know, Mr. Green. Okay.
All right. Thank you.
Thank you.
Mr. Melnick, did you have anything else or was this your one case? Well, that was fast. I guess that was his one case.
I think that was the only one.
All right. Good afternoon. Who is in booth 2?
Swinger.
Say it one more time.
Swinger.
Okay, you don't need to move towards the microphone. You can stay back where you were.
Okay. Willie Swinger.
And this is Ms. Swingers, Mr. Swingers.
Number 7. All right. And this, you said this is Ms. Woods?
It is Ms. Woods, and this is Mr. Swinger's mother.
Okay. Hello, ma'am. Oh, are they still stuck in a breakout room?
Yes.
Like close out all those rooms. Rooms are kind of iffy sometimes. Hey, Ms. Wood, we've got Mr. Swinger here. There you are.
I'm back.
Whoops. Oh, that's not the button I meant to press. There he is. Okay. So Mr. Swinger is on the calendar for inquiry. He was picked up on a bench warrant. So tell me what you think we're doing, Ms. Wood?
Judge, I think we're gonna resolve this one as well. He also has a second indicted case in judicial hold in non-complex that Mr. Peoples and I think are in agreement that we can resolve both of them. I just need to talk to Mr. Swinger real quickly before we do a plea.
Did it work in the last breakout room you were in?
Yes, Judge, and that will be a plea for Mr. Fitch.
Okay, great. Do you, is one of you Mr. Kilgore? I don't know that we've spoken with Mr. Kilgore yet, but I don't see any other people in booths. Okay. We'll figure that out. So you and Mr. Swinger would like to go into a breakout room. Let's make that happen. Mr. Swinger, hopefully the audio will work. Sometimes what has happened is that your microphone turns off so you can hear Ms. Wood, but she can't hear you, okay?
Okay.
All right, let's see what happens. Booth 2. All right, so that's Ms. Wood. Mr. Fitch is Ms. Wood. And then what were we doing with Mr. Holly?
I was going to try one more time to go out, and I think Your Honor just put me in a breakout room with him. So if there's, I appear to be in a breakout room with him. I just need to step out in the hallway.
Oh, I may have muted him. Oh, and then who's in 3 South Booth 2?
I have number 8, Mr. Kilgore, and number 9, Mr. Morgan left, besides Mr. Holly.
All right, let's unmute 3 South Booth 2 and figure out who that is. Hey, good afternoon. Who is in booth 2?
My name is Shabazz Morgan.
All right. Glad we tracked you down. Is that your case, Ms. Feely?
It is.
All right, let's. I can find him. There he is. We should be able to sort this out, I bet. This is position 12, 20 SC 175064. Mr. Morgan is here. Ms. Feely is representing Mr. Morgan. Mr. Morgan, I signed a probation warrant for you back in September of last year, about a year ago, that alleged that you had failed to report. The probation folks couldn't track you down. You had given them an address in East Point. They couldn't find you there. So it's sort of an absconding warrant. It's a technical violation. Ms. Toussaint, how much time remains for Mr. Morgan?
He has 1 year, 4 months, and 17 days.
Thank you. Ms. Feely, is Mr. Morgan admitting to the allegations?
We are for probation purposes, yes, Your Honor.
Okay. What's the only purposes we've got for them? Because it's just he didn't connect with probation. What are you recommending and what do you want to tell me about Mr. Morgan?
I'm double checking. Okay. I wanted to make sure of one thing. So Mr. Morgan.
Let me get you on the screen too, so he knows you are. Oh, you're still stuck in some breakout room. But let's use the defendant. Where's that? There it is. There you are. Okay.
So we are asking the court to consider the 52 days that Mr. Morgan has been in, given that he has not picked up any new arrests or had any run-ins with the law at all. He's 48 years old. He's single with a 17-year-old son who lives in Conyers with his mom. He went to 10th grade through at Darrell High School. And he was actually, the thing about the address is he says he was actually living there. He just wasn't home and wasn't able to connect with probation, unfortunately. He says he did finally make contact with them and they told him about the warrant. So that was the only contact. But he does say that that is still his good address and I can give it to probation again. And he has rent paid through this month. So that's still going to be his good address if he is released. But I think that was his main concern. He is working. He does sheetrock and painting and cutting grass and was doing that when he was arrested on this warrant. So we're asking the court to sentence him to 52 days to serve.
Mr. Morgan, the address that I've got is 2609 DeLoe Drive in East Point. Is that the right address?
Yes, sir.
Who lives there?
Well, I stay there with a couple of friends of mine, and we rent that house out.
Okay. So, and your claim is that you've been there for a long time and probation they didn't overlap with you.
Well, when I got out, Your Honor, I was under a lot of things. I had stayed in jail so long that, you know, my truck was about to be towed from the property. I was about to lose my place to stay, and I had contacted the probation officer to make an appointment to get in to see her. And but I guess I got there too late. She had placed a warrant on me. She told me she had placed a warrant on me, but this I have paid my money. I have money paid up through this month. So, you know, it shouldn't be a problem for me to report straight to probation like it was the last time. Yes, sir.
But you'll be going back to that address.
Yes, sir.
Okay. All right. Mr. Peoples?
Your Honor, the state's recommendation would concur with defense.
All right. Ms. Toussaint, are there any other issues you see when you look into Mr. Morgan's performance on probation, or was this it?
Do you mean like, are there any other revocations or things of that nature?
Yeah, how he's done on probation.
Let me look. I only see the one revocation order from last year.
Okay, and what was the basis for that?
Failure to report.
Okay. All right, Mr. Morgan, you're gonna need to make sure you're on point with this, that when they leave a notice at your house, your roommates get it to you. Do you have a phone?
Well, as soon as I get out, I have to get another telephone. I will go and give that information to my probation officer so they can have no problem getting in touch with me.
Okay, and you're saying that your lease or your rent is paid through the end of September?
Yes, ma'am. I know, yeah, to the end of this month, my rent is paid up to the end of this month right here. Yes, sir.
Okay, got it. All right, well, Mr. Morgan, I'm gonna revoke 60 days, 6-0. You'll get credit for the time you served, and I'm reinstating your balance. I gotta tell you, if we have to do business again because probation can't find you, it's your job to be findable. If they cannot find you, then I'm gonna not be interested in little revocations. It's gonna be a longer revocation, and that's just gonna mess stuff up for you. You don't need that. So you gotta make sure if you lose your phone and get a new number, you're letting these folks know. Probation is not hard to find. It's a big old building. And so if you ever feel like, hey, I haven't been in touch, walk on in that building and let them know you're alive and well, okay?
Sir, I appreciate it, Your Honor.
All right, Ms. Feely, anything else?
No, Your Honor.
Mr. Peoples?
No, Your Honor.
All right, that's it. Thank you, Mr. Morgan.
And Mr. Morgan will need to report. You will need to report when you are released from Fulton County. You know where probation is, right?
Yes, sir. I mean, yes, ma'am.
Okay, just make sure you do report within 72 hours because they'll get notification that you were released. So they'll be looking for you to report. And if you don't, then they'll give you a failure to report, and then we'll be sending Judge McBurney another warrant request. Okay.
Yes, ma'am. As soon as they let me out of here, I'll report the next day to probation. But they're kind of slow here. They're kind of slow here, so it might take 2 or 3 days for me to get out of here.
Yes, that's fine. You do have a few days to report because the warrants come to us from your probation officer. So.
Yes, ma'am. Okay. Okay, ma'am.
All right.
Okay. All right. Thank you, y'all. Bye-bye.
Bye. Okay, I think everything else is stuck in the breakout rooms. Ms. Wood is gone. Let me see if I close all rooms, if that will remove things. Hey, Ms. Wood. So who do you want to handle next?
We could just go in order, starting with Mr. Fitch and then Mr. Swinger, if that's okay.
No, that's fine. Mr. Fitch do you remember which booth he's in?
He's in one of the 2 north booths, I believe.
Oh, here he is. He's nodding his head. Everyone's back. Look at that.
Is this a plea? Because I have a quick announcement.
Yeah, yes. So what's the quick announcement on?
I didn't actually see number 8, John Kilgore, on the Zoom, but I spoke with him and gave him a copy of his indictment and filed a waiver of arraignment.
Okay, he was around. He's stuck waiting outside until Fitch or Swinger is done.
Understood.
But if it's just a waiver of arraignment, we're good.
We're good. And he's actually very similar to Mr. Anderson in that I just want to lay eyes on the discovery, and I think we could do a plea next week.
Great. All right. So Turquoise Kennebrew is a colleague of yours?
I believe so.
All right. That's Ms. Feely, waiving arraignment, scheduling order, and we'll work it that way. Okay.
You can put me back into a breakout room with Mr. Holly. I can finish.
Mr. Holly, are you in 4 South booth 1? Just wave your hand. Yeah. Okay. I'll see if I can pull that off. All right, you should be in a room now. I don't mind. But we just lost. I'm not good with that. Let's see. Ooh. All right. Is this Mr. Fitch or Mr. Swinger?
Swinger, sir.
Can we do that, Ms. Wood?
Yes, Judge, it'll be non-negotiated.
Okay, great. Mr. Peoples, are you ready?
I am, Your Honor. Mr. Fitch, will you raise your right hand as best you're able?
Hold on 1 second. Hold on 1 second.
Sorry, Judge.
Yes.
I don't remember if I put this in my earlier announcement. He's got that open 20 SC 176742 out of non-complex. I was hoping we could do both today.
Yeah, can you say that case number again?
Yes, 20 SC 176742.
Okay, and Mr. Peoples, you're aware that whatever we're doing is resolving both those cases?
Yes, Your Honor.
Okay, give me 1 second.
Attorney Wood, you said, what was the number again?
20 SC 176742.
Okay.
All right, Ms. Rivers, you ready?
Yes, I am.
Great. Let's go on the record with Mr. Swinger, who is position 7 on our calendar. It's 23 SC 185784. And then he has a companion case, 20 SC 176742. Mr. Swinger, my understanding is that you're prepared to enter pleas in those 2 cases. Is that correct?
Yes, Your Honor.
We're going to do that in just a moment. Mr. Peoples, so you can see on your screen there, is a prosecutor. He's going to swear you in. You'll need to answer all his questions once we get started. I need you, though, to let me know if you are willing to proceed in this virtual setting. You have a right to be here in open court, but you are in booth 2 on the North Tower, floor 2. Are you okay proceeding from where you are?
Yes, I am, Your Honor.
You also have the right to have Ms. Wood sitting next to you in that booth so you could ask her questions if you've got any questions, but she is in her office and she's not in booth 2 with you. As you've experienced, I can put you 2 in a breakout room so you can speak privately, but short of that, are you comfortable moving forward even though you 2 are in different places?
Yes, I am, Your Honor.
Then we're going to proceed when you're ready, Mr. Peoples.
Thank you, Your Honor. Will you raise your right hand? You solemnly swear the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you. You can lower your hand. Will you state your true, correct, and legal name for the record?
Willie Roy Render Swinger Jr.
Say it. I'm so sorry. Say it one more time.
It's Willie Swinger, but I have 2 middle names. Willie Roy Render Swinger Jr.
Thank you. And will you spell it for the record?
Willie, W-I-L-L-I-E, Roy, R-O-Y, Render, R-E-N-D-E-R, Swinger is S-W-I-N-G-E-R, Junior, J-R.
Thank you. Are you at this time under the influence of any drugs, medication, or alcohol?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you?
I'm 37 years old, sir.
What is the highest level of education that you've completed?
11th grade, sir.
Did you say, Mr. Swinger, you're 37, 37?
37, yes, sir. I got it out of dictionary. Yes, sir.
Do you have your GED?
No, sir.
Are you able to read, write, and fully understand the English language?
Yes, I am, sir.
You understand that in indictment number 23 SC 185784, you're charged with possession of cocaine with a sentence range of 1 to 3 years. And in 20 SC 176742, you're also charged with possession of cocaine with a sentence range of 1 to 3 years, and count 2, drug-related objects, with a sentence range of 1 day up to 12 months.
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, sir.
You understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in these indictments, including?
Yes, I have. I'm sorry, sir. Yes, I have.
All right, we gotta wait till Mr. Peoples finishes, okay?
Come again, sir?
I need you to wait until Mr. Peoples has finished his question before you answer. Okay?
Yes, sir.
Thank you.
Do you need any more time to discuss this case with your attorney?
No, sir.
You're satisfied with their services?
Say that again, sir?
Are you satisfied with her services?
Yes, I definitely am.
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
So waived.
Mr. Swinger, do you understand that this is a negotiated plea of guilty, which means the joint recommendation of the state and the defense to the court would be a sentence of, Your Honor, I actually communicated 5 serve 6 months to the court, to Attorney Wood, but I would actually request 3 years probation, serve 6 months, commuted to time served.
The range is only 1 to 3, is that correct?
Correct, Your Honor.
Okay, and the same with the 20 SC case?
Correct, Your Honor. And count on the 20 SC, we'd ask to null pros count 2.
Okay.
Completion of an alcohol and drug evaluation and treatment, and no alcohol or illegal drugs. Do you understand that, Mr. Swinger?
Yes, I do, sir.
You understand, however, that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes, sir.
You understand that if the court decides to order a sentence that differs from the negotiated plea, that you have the right to withdraw your plea of guilty?
Yes, sir.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes, sir.
Do you understand that if you are placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, I understand.
You understand that you are not allowed to possess nor use a firearm while on probation?
Yes, I understand, sir.
Are you a citizen of the United States?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand all these rights?
Yes, I do, sir.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No, they haven't, sir.
Is your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you, in indictment ending in 784, how do you plead to possession of cocaine?
Guilty, yes, sir.
And in indictment ending in 742, how do you plead to the count of possession of cocaine?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
You understand that you have only a limited right to appeal this guilty plea conviction?
Yes, I do, sir.
You understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes, sir.
You understand that you have only 12 months from today for a misdemeanor and 4 years for felonies to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes, I do.
You understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea.
Yes, sir.
You understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself.
Oh, yes, sir.
Your Honor, if this had proceeded to trial, the state would have expected to prove that an indictment ending in 742, that on March 11th of 2020 at 1192 Pryor Street Southwest in Atlanta, Georgia, in Fulton County, Mr. Swinger was arrested by Atlanta Police Department for being in possession of a suspected cocaine and a pipe. The officer had been dispatched to that location in regards to a criminal trespass call, and upon arrival, he observed the accused fighting with another male, and while conducting a safety frisk of Mr. Swinger, a small bag containing cocaine and a pipe was found. And in indictment ending in 784, one second, Your Honor, I apologize. On August 10th of 2021 at 206 Farrington, Fairrington Avenue in Atlanta, Georgia, in Fulton County, law enforcement came into contact with Mr. Swinger, at which point he admitted that he had to the crack cocaine in the room that was his. It was roughly about 3 grams in the bedroom. Counsel, do you stipulate that there's a factual basis for this plea?
Thank you.
And Your Honor, that's all from the state. Your Honor, we will be asking for this recommendation. We believe it's a fair and equitable close to these cases. The initial case, the 20 SC, was some time ago. And while I understand that drugs are not permitted and are illegal, the small amounts, as well as the defendant's willingness to accept responsibility, we believe that this is a fair resolution to this case.
Mr. Peoples, it was 3 years to serve 6 months, reduced to time served, balance probated. I may have missed, were there special conditions?
Alcohol and drug evaluation and treatment, Your Honor.
Okay. Is there a reason you didn't consider, and it may be because this is the kind of a plea and arraignment calendar for Mr. Swinger, you didn't consider Mr. Swinger for drug court or some more formal type of treatment, which seems like these cases are from a while ago, 2020 and 2021, but they're the kinds of cases that say to me, maybe we ought to get Mr. Swinger some treatment.
Understood, Your Honor. And I did think of that. And I think that was something that initially Attorney Wood had placed on my radar. However, as we came to a resolution, it seemed like this would have been one that would allow Mr. Swinger to get out of custody and out of the Fulton County Jail. So that's kind of where we came to today.
Okay. Ms. Jackson, can you share with me the criminal history information you have on Mr. Swinger?
Yes. The defendant has 12 cycles. The defendant's last arrest was July the 17th, 2022, with the City of Atlanta Police Department for entering an automobile and possession of tools for commission of a crime. There is no disposition for that arrest. I do see the open case is still pending for possession and use of drug-related objects. That case number is 20 SC 176742. And he does have misdemeanor convictions listed in the GCIC. It's one in 2011 for obstruction of an officer, and one in 2010 for battery. There's an additional one in 2010 for simple assault. Nothing in addition, Your Honor.
Thank you. Ms. Wood, how are we going to get Mr. Swinger some help?
Thank you, Judge. So I just do want to start out. His mom is there in support in the courtroom, Miss Annie Swinger. I've spoken to her. She is going to allow him to live with her. She has an Atlanta stable address. He has indicated to me that he has received help from a facility on Glenwood. I have not had a chance to reach out to them and confirm what type of treatment he's received there. I do believe this is a fair resolution, as Mr. Peoples' recommendation includes the drug and alcohol evaluation and treatment through probation. If probation deems him suitable for further treatment, I trust that the Department of Community Supervision will see that he gets that. He's been in 42 days so far. He's 37. He's from Atlanta. He has a stable job that he can return to at a tire shop. He has one child, a 13-year-old son. The 20 SC case, there's no amount listed. I'm sure it was a very small amount. And the case on the calendar, it was actually 0.3 of a gram that was found. So it's recreational use, Judge. I would just ask that you accept the sentence as the state has recommended.
Okay. I don't know about the phrase recreational use, but it is clearly personal use. I agree with you on that. Okay. Mr. Swinger, is there anything you want to add?
No, Your Honor.
So when you get out, you will live with your mother?
Yes, I will, sir. Your Honor.
And Mom, how long can your son stay with you? Does he get 3 days to get his act together, or 3 months? What's your tolerance?
Very tolerant. I really want to. I would love to support him, but I'm going to be pushing him and trying to get him into some type of real program to help him out.
Okay. Well, he is lucky to have you around. Mr. Swinger, I'm going to accept your pleas in both the cases. I find there's a factual basis for both, and that your pleas are knowing and voluntary. Voluntary means no one's forcing you to enter these pleas, and knowing just means you've understood all the things we talked about. Do you agree with both those statements?
Yes, I do, Your Honor.
Okay. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, which you will be for about 3 years, on these two cases, if you have minor issues, maybe you miss a meeting or something, you and probation will work through that. But if it is more serious, you get arrested again, that's a violation that'll come back to me and we'll work through it. Ms. Wood, may my staff sign your name to the 2 indictments? I think one is an accusation, but the 2 charging documents indicating the guilty pleas?
Yes, Judge.
Mr. Peoples?
Yes, Your Honor.
And Mr. Swinger, is it okay if we sign them for you as well, since you're out there at the jail?
Yes, sir.
Great, we'll do that. Mr. Swinger, in 20 SC 176742, on count 1, I am sentencing you to 3 years to serve 1 month with a balance on probation, and you will get credit for all the time you served, which is more than 1 month. So you should get out tomorrow. If not, you should reach out to Ms. Wood, and she'll figure out what's going on. Special condition of probation number 1 is that you submit to a drug and alcohol abuse evaluation. And if that professional recommends any form of treatment, you'll need to engage in that treatment. And the second condition of probation is that you, at least for the first 2 months of your probation, reside with your mother. Okay?
Yes, Your Honor, I understand.
Your sentence in 23 SC 185, count 2 is dismissed. your sentence in 23 SC 185784 is the exact same. So it'll run concurrently with your other sentence. So you'll be on probation for 2 years and 11 months. And I'm adding that extra probation in there because just in case you aren't taking care of yourself and there's some drug use, that will give me the ability, maybe, if we have to have a revocation hearing, to get you into drug court. Because I can revoke you into drug court. I can't get you into drug court right now because that didn't get lined up. But I want to make sure that we build in some space to do that. But you may have figured out some aspects of your addiction, and it may be that that's less of a problem for you. We'll figure that out. Do you have any questions about anything I just said?
I do not, Your Honor.
Okay, Mr. Peoples, anything else for the state?
No, Your Honor.
Ms. Wood, anything else on behalf of Mr. Swinger?
No, Your Honor, thank you.
Ms. Tucson, ask Mr. Swinger what you need to get from him, please.
No problem. Miss Wood did send me over the information, so I appreciate it, Miss Wood. Just to confirm, you're going to be living 1034 Washington Street, Apartment 5, Mr. Swinger?
Yes, ma'am.
And Miss Annie, her phone number is 404-641-5512.
Yes, ma'am.
Okay, that is where I will contact her with reporting instructions. Fulton County now reaches out to you to do your intake. So that has to be a verifiable address, okay?
Okay, yes, ma'am.
So we will reach out to her to set up your intake, okay?
Yes, ma'am.
Okay.
Thank you.
No problem. Thank you.
All right, Mr. Swinger, you are free to go. Again, if you don't get released tomorrow, reach out to Ms. Wood, okay?
I sure will, Your Honor. Thank you. Hey,
Good luck. All right, bye-bye.
And Judge, to confirm that second case number, 20 SC 176742?
Yes, ma'am.
Okay, thank you.
I've got an update on number 11, Mr. Holly.
Okay. Mr. Fitch, we need to find, and Mr. Holly, what's the update?
Mr. Holly has a lot going on. As
He
they
does.
but he would like to go ahead and wrap this portion of it up if we could. He had one CP case, couldn't make bond on that one, picked up a second CP case for which he's now being held with no bond. So I think we could just revoke, and I don't know how much time he has left, but
5 years, 11 months, 22 days.
so it's not going to probably make a practical difference about when he gets out, but
Okay. I need to figure out how to get those folks back on the screen. I'll do that. And Mr. Kilgore, we don't need because of waiver arraignment. So Ms. Farrell, Mr. Kilgore is free to be returned to his cell. Thank you.
Okay, thank you, Judge.
You bet. Hello, my friends. I have one more plea to take. So the jail Zoom calendar has taken a little longer than I forecast. You're welcome to stay. I don't mean to make you wait around. I have the ability to chat after I take that plea, but I know you all have other things to do. So tell me how you'd like it to work. Okay. And if you want to be in a more comfortable space, you can go into the jury room, because I'll just come straight into the jury room from here. And you can just come right up here like you were jurors, but you're not. I would never want you on my jury. You'd be great grand jurors. All right, let's see if we can find Mr. Fitch. I bet he's right here. Move to, let's do it this way, to north. Hey, are you Mr. Fitch?
Yes, sir.
Excellent. I tracked you down. Good to see you again. Ms. Wood, is this case a plea?
Yes, Judge.
All right, then let me make that get off the screen. Mr. Fitch, if you are prepared to go forward with a plea, then Mr. Peoples, who is the other person on your screen there, the prosecutor, is going to put you under oath. Before we do that, I need to make sure that you are comfortable with this setup, by which I mean these two things. You have a right to be here in court, which is a public space, but you are in a booth at the jail. Are you waiving your right to be here physically in my courtroom?
Yes, sir.
You also have the right to have Ms. Wood right next to you. So if you've got any questions, you can just lean over and say, wait, what did the judge mean by that? She is in her office. You are in what we'll call your office. You're not in the same place. If you need to speak to her privately, I can make that happen by putting you back in a breakout room. Are you comfortable proceeding with Ms. Wood not by your side?
Yes, sir.
Let me know if you need to speak with her.
I'm good. I can go.
Right. No, I know you're good, but will you let me know if something comes up and you want to talk to her?
Okay, yeah. Yes,
All right. Once you're under oath, make sure you answer Mr. Peoples' questions truthfully and completely. Mr. Peoples?
Thank you, Your Honor. Mr. Fitch, are you able to hear me?
Yes, sir, I can hear you.
Thank you. Will you raise your right hand? You solemnly swear the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can lower your hand. Will you state your true, correct, and legal name?
Kevin Williams Fitch.
Can you spell it for the record?
KEVINWILLIAMSFITCH.
Thank you. Are you at this time taking or under the influence of any drugs, medication, or alcohol?
No drugs. I'm taking medication. Is blood pressure pills.
Okay. Does it affect your ability to understand this proceeding?
No, sir.
Okay. How old are you?
37.
And what is the highest level of education that you've completed?
11th grade.
Do you have your GED?
No, sir.
Are you able to read, write, and fully understand the English language?
Yes, sir.
You understand that you're charged with the following offenses. Count 1, possession of a firearm by a convicted felon with a sentence range of 1 to 5 years. And count 2, possession of a firearm by a convicted felon with a sentence range of 1 to 5 years.
Yes, sir.
You understand that you have the right to plead either guilty or not guilty to these charges.
Yes, sir.
You understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial.
Yes, sir.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss this case with your attorney?
No, sir.
Are you satisfied with their services?
Yes. Yes, sir.
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
So waive.
Mr. Fitch, do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court will be a sentence of 5 years of probation and a weapons forfeiture? Do you understand?
Yes, sir.
You understand, however, that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes, sir.
You understand that if the court decides to order a sentence that differs from the negotiated plea, that you have the right to withdraw your plea of guilty.
Yes, sir.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts.
Yes, sir.
Do you understand that if you're placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
You understand that you are not allowed to possess nor use a firearm while on probation?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
You understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. You understand all these rights?
Yes, sir.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charge of count 1, possession of a firearm by a convicted felon?
Guilty.
And count 2, possession of a firearm by a convicted felon?
Guilty.
Is your guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
You understand that you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
You understand that unless counsel is substituted or permitted to withdraw, that defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes, sir.
You understand that you have only 12 months from today for a misdemeanor charge and 4 years for felonies to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes, sir.
You understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea.
Yes, sir.
You understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself.
Yes, sir.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on October 25th of 2021, law enforcement was executing a writ of possession for the address of 3378 Greenbrier Parkway Southwest, apartment 8307 in Atlanta, Georgia, in Fulton County, on an eviction. They knocked on the door and announced themselves as the Marshal's Department here for an eviction. No one answered, and they attempted to gain entry with a key given to them by a maintenance supervisor. The key worked. However, the tenant inside of the residence had the privacy lock on. Shortly thereafter, a male identified as Mr. Kevin Williams Fitch answered the door and opened it. Law enforcement entered the apartment, explained why they were there, and during that conversation, they asked Mr. Fitch, was his bedroom the first to where his bedroom was? He confirmed where it was. They asked if everything was in that room was his. He said yes. They asked if he had any firearms in the room, and he stated yes. He stated that the weapons were in the bed covered with a blanket, and law enforcement retrieved a black rifle and another black rifle as well. Counsel, do you stipulate there's a factual basis for this plea?
We do.
Thank you. That's all from the state, Your Honor.
So before I hear about criminal history, Ms. Nelson and I both have a question about the indictment. Count 1 charges Mr. Fitch with possession of a firearm by convicted felon under section 133, and it references a rifle. That's because he has a prior felony. He's got involving possession of a firearm. Count 2 charges him under 131B, and it says handgun, not rifle, so a different type of gun. So I'm trying to understand what the difference is between the two, unless it's two different guns. If it's because it's two different guns, you just said there was only a rifle, or there were two rifles, but not a handgun. So I'm just trying to balance the two. If we can't, then we ought to null pros one of the counts. It's going to be the same sentence either way, and figure out what we're going to do.
Correct, Your Honor. The report indicates that there were two rifles, but to make it cleaner, than the state would ask to null pros count 2.
Okay. Thank you.
Thank you, Your Honor.
You're welcome. Ms. Jackson, I know there's some criminal history out of Alabama, because that's at least one prior felony that is the predicate here. What else do you have for Mr. Fitch, please?
Okay, you're correct. He does have that one felony conviction out of Alabama. It was in 2009 for dangerous drugs. And he has misdemeanor convictions out of Alabama as well. It's one in 2020 for criminal trespassing, one in 2018 for criminal trespassing, and one in 2012 for assault, and one in 2005 for public intoxication. Nothing in addition, Your Honor.
How many total cycles?
17 cycles.
Okay, and the most recent?
The most recent arrest was August the 31st, 2022 in Fulton County for a failure to appear.
All right. Thank you so much. Ms. Wood.
Thank you, Judge. Mr. Fitch is 37 years old. He is from Alabama. He has two sons, ages 12 and 18. He does have an 11th grade education, and he is a skilled brick mason. That is the work that he was doing before he got arrested earlier this year. Judge, Mr. Fitch shared with me that he had been working with a rehab facility in Alabama called Center of Hope. He wanted me to share that with you. I actually spoke with them this morning. They were very nice. They asked me to call back this afternoon. He's hoping that he'll be able to return there and finish out some work that he's been doing on himself. If he's not able to go back there, though, he does have a stable residence that he can go to here in the Atlanta area. He does have family support. He has a sister and a friend that lives here. He has also served 45 days in custody on this bench warrant. We would ask that you accept the state's recommendation in this case.
Okay. So Mr. Fitch, your preference would be to go back to Alabama, but you understand that if you actually have to stay in Georgia for a little bit while they transfer supervision of your case to Alabama, you would stay here and you have a safe place to stay?
Yes, sir.
Is that with friends or with family?
A girlfriend.
Okay.
Lady friend.
But that's a stable place for you to be?
Yes, sir.
Okay. Do you have any questions about anything Mr. Peoples or Ms. Wood has been saying?
No, sir.
What happened to your eye?
It was a cyst. I've been there for like 2-3 years.
Oh, so this is not something that happened at the jail?
Nah, no, sir.
Okay. Got it.
I'm trying to get my, I just got my insurance, mama insurance, and I'm trying to get it removed and stuff.
Okay. Well, I hope that works out for you. Well, Mr. Fitch, I find there's a factual basis for your plea. You had that room in that house, and your gun or guns were in there. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this, and knowing means you've understood the things we've talked about. Do you agree with that?
Yes, sir.
Okay. I'm sentencing you under the Probation Options Management Act. If you have a small problem when you're on probation, and I hope you have none, but if you have a small one, maybe you failed a report one time or something, probation and you will work that out. But if it's a bigger deal, you get arrested again, anything like that, that'll come back to me. Ms. Wood, may we sign your name to the indictment?
Yes, Judge.
Mr. Peoples?
Yes, Your Honor.
All right, Mr. Fitch, is it okay if we electronically sign your name to the indictment indicating your guilty plea to count 1?
Yes, sir.
Okay. I'm going to sentence you on count 1 to 5 years to serve 1 month with the balance probated. You'll get credit for all the time you've been in, which is more than 1 month. So you should be released shortly. The only special condition of your probation is that you will forfeit any of the firearms that were seized, and they'll get bent into whatever happens with that when the police forfeit firearms. Ms. Wood, have you shared with Ms. Tucson the contact and address information for Mr. Fitch's friend here in the Metro Atlanta area?
Yes, Judge, I did.
Okay. Mr. Fitch, when you get out, you're going to need to reside at that local address with the lady friend. I am all for having you get back to Alabama if that is a supportive environment for you, but you need to do it consistent with probation saying it's okay. Do you understand that?
Yes, sir.
All right. Mr. Peoples, anything else?
Nothing further from the state.
All right. Ms. Wood?
Thank you, Judge.
Ms. Tucson, do you need to share anything with Mr. Fitch?
Mr. Fitch,
Yes, ma'am.
so you will be staying at this residence for the time being, correct? You are not moving to Alabama or anything?
I'm gonna be there. I'm gonna try to get back to Alabama. But yeah, I'm gonna be at that residence.
Okay, for how long?
I guess for like a month.
Okay, because that's where they're gonna come and do a residence check. I have 3528 Mount Gilead Road, Southwest, is what Ms. Wood provided.
Yes, ma'am.
And the phone number you can be reached 470-914-2453 or 334-728-6322.
It's, what's the first one you said?
470-914-2453.
Yes, ma'am.
And what is her name?
Samika Weathers.
Weathers?
Yes, ma'am.
All right, and this is her phone number.
Yes, ma'am.
Okay, so you will be contacted at this phone number and address to report for probation. They're gonna call you for intake, okay?
Okay.
All right.
I got a question.
Yes, sir.
When I get released, do I got to report to the probation? Because I'm not familiar around here.
No, you're gonna be contacted by a probation officer for intake.
Okay.
Okay. Just make sure you're at that address, or if the probation officer comes to that address, whomever is there will say, yes, Kevin Fitch does live here. That way you will be, in compliance, and they'll still need to get a hold of you, but at least they know that whoever they talk to is verifying that you do stay there.
Okay.
All right. Good luck, Mr. Fitch.
Thank you.
All right. You free to go.
All right, thank you. Thank y'all.
So there should only be one position left, and I'm going to see if I can fish him out of the breakout rooms the way things have been going here. Let's see. 4 South Booth 1. And Ms. Wood, you're able to handle Mr. Holly's case?
Yes, Judge.
All right. Hey, Mr. Holly, can you hear us?
Yes, sir.
Excellent. Thank you for your patience. I know it's been a long afternoon for all of us. You're the last man standing or sitting. So here's what I was told by Ms. Feely, Ms. Wood, while you were doing something else, is that Mr. Holly has a bunch of fish to fry. He's not going to be able to sort out the 2 CP matters, the unindicted cases that are holding him, and on at least one of them, he's got no bond. But he would like to work through the revocation on this 19 SC case. Is that correct?
Yes, Judge.
Okay, well, let's do that. I'm going to get your warrant back up. All right, so this is position 11 on our calendar, State versus Jabari Holly, 19 SC 167302. And as I told you before, Mr. Holly, in June of this year, I signed a probation warrant that alleged that in May of this year, you committed some crimes concerning driving recklessly, eluding the police, having a gun, etc. It's one of your 2 unindicted cases, and that's what's alleged in there. Ms. Wood, is Mr. Holly stipulating for purposes of this revocation that he got arrested on those charges?
Yes, Judge.
All right. We know from Ms. Tucson that Mr. Holly has just shy of 6 years remaining on his probation. What are you recommending, Ms. Wood?
We are recommending that 130 days be revoked and he be reinstated to probation.
All right. And Mr. Peoples, your recommendation?
Your Honor, the state will be asking to revoke 210 days and return to probation.
Reinstate. All right. Mr. Holly, anything you want to add? Are you comfortable with what Ms. Wood had to say?
Yes, sir.
You're good?
Yes, sir.
Okay. All right. So, Mr. Holly, in light of what you were charged with in this original case, the 19 SC, and then what you got arrested for in May of this year, I'm going to revoke 240 days, 240. You'll get credit for all the time you've been in, and you're going to continue to get credit while you are waiting to sort out your other cases, including the one where you've got no bond. So I don't think this is going to change much for you, but I think that's a reasonable revocation given the seriousness of the charges, and I'll reinstate the balance of your probation. Ms. Tucson, do you need anything from us?
No, Judge, 240 days revoked, credit for time served, reinstate the balance on.
Exactly.
302. Okay.
You got it.
That's, I mean, eventually, when everything gets, situated, he will have to report eventually.
Right. He's got to work through his 2 unindicted cases though, and then he'll be in a position to make his next big move. All right, Mr. Peoples, anything else?
Nothing further from State Attorney.
Ms. Wood?
Hi, Ernie, thank you.
All right, Mr. Holly, I'm sorry we made you wait so long. I appreciate your patience.
It's all right, Mr. It's all right, Mr. McBurney.
All right. Take care.
No problem.
I think that covered the calendar. Mr. Kilgore, we didn't see, but we didn't need to because Ms. Feely took care of his business. So I appreciate everyone's flexibility. We had a little technical hiccup at the outset. We worked through that. I am in Cobb County the next 2 days, so you guys can just be getting all excited about the upcoming trial calendar.
What day would the our meeting be, Your Honor?
To talk about the trial calendar,
Yes, sir.
I'm going to add that to my list. I have to talk with Ms. Nelson. We need to line that up.
Okay.
Trial calendar meeting. The answer is it would have to be Monday or Tuesday because Wednesday we call the calendar. So I will pour over my schedule and see what we can do.
Thank you so much.
All right. Well, thank you, Ms. Tucson. Thank you, Ms. Jackson, Ms. Rivers. You all were helpful and you're free to go.
Have a good
Thank
night.
you. Have a great one, Judge.
All right. Bye-bye.